4CA.
By the way, this morning you might have picked up on this one. This is bizarre. I mean, the committing of really serious crimes is now become the domain of even younger and younger children. Have a listen to this. A baby-faced teenager started trafficking drugs, including cocaine, when he was 15 years old, and supplying firearms, until family bailed him out over a drug debt that resulted in threats to put him in a car boot. The 17-year-old, that's what he is now, the 17-year-old's relatively sophisticated trafficking operation that involved near wholesale amounts of drugs started at 15. Saw him sentenced in the Supreme Court yesterday. He'd earlier pleaded guilty to trafficking, possessing drugs and 5 counts of supplying weapons. The court heard the teenager trafficked drugs, cannabis, cocaine and MDMA from August 2022 to February last year while aged 15 and 16. The prosecutor said the youth, who can't be identified because of his age, had no prior criminal history. Well, if he had prior criminal history, he would have been 14. Oh, seriously. Anyway, here's the quote. He said the business was relatively sophisticated. It involved a relatively large customer base and the employment of couriers and the sale of quantities of drugs which were approaching wholesale amounts. Due to mitigating factors, including the teenager's young age, lack of history, he started at 14 and at 15, and substantial cooperation, Mr. Sherry said probation was appropriate. The fact of the matter is here, this, with social media, this bloke becomes a hero. He'll be lauded among the teenagers or whatever. They're lauded these days as living legends by bloody social media because they're seen as walking free, no consequences. And to me, it serves as almost an encouragement to other young kids to get out there and potentially earn lots of money, be seen as a hero, etc. When you walk free from court, and it just gets worse and worse, this teenage crime. Anyway, that's not the main point. I'm going to talk with Terry Goldsworthy. Why? Because he's in a position to comment on these matters and where we are and where we might be going. Just briefly, it says a Queensland Magistrate has backed the state's courts to tackle the mounting youth crime crisis as he revoked the bail of a 16-year-old accused of stabbing another teen in the face. The magistrate quoted legislation yesterday as he said it was up to the courts to decide whether or not a juvenile offender posed a risk to community safety and if a tough sentence should be imposed. And this is interesting, talking about a tough sentence for a 16-year-old. Now, the Redcliffe Magistrate granted an application by the Courier to report on the case of the 16-year-old who allegedly stabbed another boy, 17, in the face, hand and neck. It was revealed that the accused had been in court 3 times this year. This is April. Revealed the accused had been in court 3 times this year, with Mr. Bucknell deeming the child, who couldn't be identified, an unacceptable risk to the community. This is what he said, quote, "I hear about weak youth justice laws and everything like that. The courts are armed," he said, "the courts are armed with significant powers through Section 48 AAA of the Youth Justice Act." Anyway, Mr. Bucknell said the section provided powers for courts to impose tough sentences or penalties on youth offenders if they posed an unacceptable risk to the community or were likely to reoffend. This bloke's been before the court, this kid, 3 times this year already. Anyway, I'll cut to the chase here. The 16-year-old was already on bail at the time of the alleged offence. He'd been convicted of 8 breach of bail offences and 6 finalised breaches of bail. The police prosecutor, referred to the teen's action as a massive escalation in violence. She said, the police prosecutor, his history simply speaks volumes. I don't think there's any other submission, she said, I can put on the record other than the fact that the charge before the court today is of an extremely serious nature. It's a massive escalation in his offending. It's the 3rd time that the accused has been subjected to revoked bail just this year. Now, I'm just crossing to Terry Goldsworthy. Terry deals with these sort of matters all the time. And fundamentally, he has an understanding of where we can go on this, what is possible and what isn't, and what might work and what might not, because we're all desperate for answers. Every time our loved ones walk out the door these days, our children, our parents, our grandparents or whatever, we're walking into the path of danger because it's just expanding constantly, this juvenile crime all the time. He's the Associate Professor in Criminology at Bond University, Dr. Terry Goldsworthy. Good morning.
Yeah, good morning, John.
Terry, you won't deny that we out here in victim land are getting more and more desperate for something to ease this explosion of juvenile crime. Can you just give us the background of what's going on and why the courts, according to this particular prosecutor, why the courts who have the ability to impose harsher sentences don't or can't?
Yeah, so the section that the judge is referring to, that article, is Section 48 under the Youth Justice Act. And it looks at, releasing children to custody and what risk assessment needs to be done before they're released. And it clearly says that, the courts must decide to keep a child in custody if they're satisfied that the child is an unacceptable risk in terms of committing another offence that's going to endanger the community or endanger the child or the welfare of another person. They can also keep the child in custody if the child is not going to surrender into custody in accordance with their bail or is likely to commit an offence whilst on bail. So the section is quite strong. It says that they must keep the child in there if they are satisfied. The problem is, though, that the court's coming back saying they're not satisfied. And I think this judge yesterday in his commentary was saying we actually have strong bail laws there if you're prepared to use them. So it may have been a critique or a side swipe at his fellow judiciary, I suspect, in terms of we don't need stronger laws, we just need to use the laws properly that are there. Having said that, though, I mean, we had, youth justice data tells us that there are 3,400 or thereabouts young people with a proven offence in 2023. Now, in terms of bail applications, the QPS in the financial year 2022-23 only appealed 16 bail decisions. I would imagine there would be many, many more that probably should have been appealed.
Really? This is interesting indeed. Are other professionals aware of your belief on this particular matter?
Well, I mean, they appealed 16. 5 of them were successful. Their appeal was granted. 4 of them were dismissed and the others resolved themselves before the appeal could be heard. So, on the basis of that, they've almost got a 50% strike rate of winning. When you're talking about 3,500 offenders, there's any number of bail decisions involved around there. If you put that in the context of the fact that we know from the Atkinson report, 53% of youth offenders on bail reoffended, 19% of them went and did serious offending, and 7% did offending that led to death or grievous bodily harm. If you've got 53% of your youth offenders on bail, I would suspect that there would be more than 16 bail matters that you would probably be worthwhile reviewing.
Now, this magistrate, Mark Bucknell, fundamentally, as you hinted, he's fundamentally saying, these magistrates should do more. There's more available to them to provide disincentives to all those other potential criminals out there. What do you believe about his position, and why can't we see more of magistrates saying the same thing? So hopefully we'll get more effective decisions.
Well, I think it doesn't mention whether this youth has been declared a serious repeat offender, in which case, detention as last resort doesn't matter, doesn't come into effect. But I guess what he's saying is he's taking a viewpoint that community welfare is more important than not detaining a child. And, that's something I've been arguing for some point in time now that, this detention as a last resort, some kind of holy grail that they keep holding on to, is something that is inflicting harm on society. And, I think the government's realised that and scrabbling to try and fix it. Maybe it's time some members of the judiciary realise that community welfare should be paramount. And if the child is going to continually reoffend, not only are you putting the community at danger, but given the nature of much of the offending of these youth offenders, you're also putting them at danger.
But, Terry, there's nowhere to bloody put them.
Well, that's true, John. That's, that is the case. I was just looking at a question to Parliament in terms of the longest stay of a youth offender in a police watch house, and it came out in the last year that, one youth had stayed 31 days in a police watch house because there was nowhere to put them or transfer them to. And there was a 10-year-old who stayed 5 days in a watch house. So, this is the problem the government's got. It's failed to, do any long-term planning in terms of how they would deal with juvenile offenders once they had to toughen up the laws, because they loosened the laws. They tinkered with the criminal justice system over a period of years from 2016, where they gradually reduced and weakened the way we, deal with our children who get into the criminal justice system. And then they've tried to fix it up by getting tough. But, of course, as you rightly point out, it's a bit hard to get tough when you've got nowhere to put these kids who are problematic.
Exactly.
And even if you do put them in, they're going in and out that fast so that they can free up places for other kids to go in. So there's really no rehabilitation taking place in regards to the core issues that are affecting these offenders. And we got some interesting data come out about a month ago that tells us now that 70% of youth offenders reoffended within 12 months. 81% have used at least one substance. 38% have used ice or other methamphetamines. They're exposed to DV. 44% have behavioural or mental health issues that may be diagnosed or suspected. So there's a whole gambit of issues behind youth offending that, if you're just putting them in and out very quickly of these centres, will never be addressed, and it's just going to be a vicious circle.
Terry, it's such a farcical situation up here that we get hints that are very easy to read, hints from our local police saying, everybody lock up really well your homes, your cars, and straight away there's a significant quota of these offenders being released together out of Cleveland. And the next day you go from 1 stolen car to 8 stolen cars to 9 stolen cars. It lasts about 3 or 4 weeks till they're all rearrested again. And back to Cleveland, you get the hint then, look, we've come back to 0 stolen cars or whatever for a weekend. That's how predictable this farcical system is. Now we've got this situation in Alice, and you say, it's in the middle of, what are you talking about that for? It's not your problem. Yes, it is. Now, Mount Isa is copying the Alice Springs issue because so many are coming there, and of course there's the same sort of copycat business. Now, Mareeba and Cairns and Townsville are copying it too. So if we don't find reform, we have a very grim future up here.
Oh, you do. And it comes back to those 3 areas I think I've talked about before. We've got the pre-crime, the crime and the post-crime. And, we do have some, like intensive case management now, which is being rolled out, in small numbers I may add, though, actually addresses a number of those pre-crime issues where the family structure has failed, where the child is not engaging with education, etc., things like that. If you can stop them going into crime, it's much better. The crime part in the middle, that's where, decisions like this made by the judge in terms of bail are crucial, that the community is protected from these hardcore criminals. And we're only talking about the serious repeat offenders here. We're not talking about, your 15-year-old shoplifter who does it once and never goes back.
Oh, yes, of course.
And, post-crime, again, is where you put these kids who, get sentenced, go in, come out with some sort of skills. Someone flagged a program in Portugal where, when they're in the rehabilitation centres, they're actually taught a trade by tradies, or they're given access to some tertiary education that will allow them to get an education to go and be productive members. So I'm fully supportive of that. I mean, I want the community protected. Yes, you should be held accountable for your crime, but while they're in there doing that, we can actually do some positive things so they don't come out and reoffend, and then we don't have that situation you're talking about where they just go in, get released, and then they unleash a crime spree again.
I really appreciate your contributions, Terry, and they're energetic, and it gives us the scope up here to actually hope for some relief in the future. And thank you for your contributions.
Thanks, John.
That's Terry Goldsworthy, or Dr. Terry Goldsworthy, Associate Professor in Criminology at Bond University. My God, we've still got a long way to go, haven't we? 28 minutes past 10.
846 4CA.